5708. I have Mr. Anagnostou. I have Ms. Winkles. And Mr. Anagnostou, I did receive your notice of appearance. Thank you for providing that, a bench copy of that. My question was, it looked like the court had appointed Mr. Goodday previously, and so I was just curious about sort of your representation.
I wasn't aware that counsel was appointed for Mr. Radcliffe. He wasn't aware and thought he was going to be unrepresented today. I ended up doing a notice of appearance. My clients are the Fletchers, and they were referenced in a lot of recent declarations, and they waived the conflict for me to be here today. But I have a conflict because I've represented them against Mr. Radcliffe, but they all agreed, even Mr. Radcliffe, that he wanted representation. So I didn't know he had representation. That's fine.
Okay. Very good. And that's fine. You can stand in today. You're here, and I don't have Mr. Go ahead, Ms. Winkles.
Yes, and just so you're aware, obviously, I believe genetic testing is a foregone conclusion, and I believe that's the only reason we're here. Right. My clients just wanted to make sure that if there was any request for any visitation, that be obviously put off until a guardian ad litem or someone else well down the line is appointed. So I believe the genetic testing is the only reason we're here, and if that's the case, obviously, it's most likely a foregone conclusion.
Okay, very good.
I agree with Ms. Winkles. That's the issue today.
All right, very good. That was how I viewed it as well, as the only motion sort of on the table was the genetic testing. I do have a proposed order in front of me. You did not prepare that order, Mr. Anagnostou. Would you like to prepare a new order and send it, or do you want to work off of the order that's been provided to me today?
Whatever's most convenient. I know Mr. Radcliffe, wants to get this process moving along, so.
I'm going to go ahead and let you and Ms. Winkles develop a form of an order and submit that. Sounds like it should be agreed, so I don't have any concern there. The only concern, I will order the genetic testing that's appropriate for the child. What that takes us, though, to is the costs. Right. So your client left that section blank. This is not something the court generally pays for. What's your client's plan as far as payment of the genetic testing costs?
Well, recently I know he had a head injury and he was incarcerated, but he's now out and trying to find housing and various other things. So he doesn't have any funds really. So I'm not sure if the whole cost is, if the state was involved seeking child support, they'd be paid for that. But
right. But this is a case where the state is not involved. Ms. Winkles, do you want to speak as to the costs?
Yes. So obviously I represent the guardians. Since they weren't involved in the conception of the child whatsoever, and they don't have even a vested interest in who is the father, as they have a minor guardianship, the cost should definitely not be borne by them. I believe in this case, and I know very little about mother, but I believe mother is completely indigent and has no employment. So it's highly unlikely mother would ever be able to come up with the costs. I don't believe there's child support even being paid to my clients at this point by either side, if I remember correctly. Now, there's probably an order, but I highly doubt that it's being paid. I believe it would be a fall. Unfortunately, as horrible as it is, it would fall on father to pay for the genetic testing. Father may have had traumatic brain injury, but most likely he does have access to some sort of funds, especially if he has a limited notice of appearance of counsel today. That tells me that somebody is paying. In any event, for Mr. Anagnostou's service today, I believe they'd be able to pay for I can't remember how much it is now, a little over $100, I believe, for the genetic testing.
Okay. I appreciate everyone's arguments. In this case, this is what I'm going to do. I'm going to order the moving party, in this case, Mr. Radcliffe, to bear 100% of the costs at this point, but with a reservation that can be addressed later in the case. So there may be the obligation subsequent for some amount to be paid back, but I'm going to have somebody has to pay it up front. And in this case, it's going to be the moving party, Mr. Radcliffe. So I think with that, I don't think either of you would have any other questions. Mr. Anagnostou, I'll have you prepare the form of the order and you can send it to Ms. Winkles. If there's any issues, I'll just let you note it up for a presentation, but I'm not anticipating any, so I'm not going to advance a date today.
Okay. So,
all right. Thank you, Your Honor.
Put in the order that he pays the cost of it.
With a reservation that...
right.
Yeah.
Okay. Thank you.
All right. Very good. Thank you both. Anything further on this matter? So, sir, I see you have filed documents, but what I don't see in my file is what's called a proof of service. And that's just a document that lets me know that everything that you filed in this case has been served on Mrs. Knowles. Has that happened?
Yes, it says it's filed in. I got a phone call. I went down there for council stuff like that on Monday, and they said, and they just printed this out. Basically, is what it was. I don't know if she'd been served or anything like that. So
You got paid the.
yeah, I paid the fee and everything else. So I'm not really sure.
Okay, so you paid the, hold on, I'll get to you, Ms. Knowles, I promise. So, sir, I know, I can't hear him very well either. Sir, what I'm going to have you do is I'm going to actually have you turn your video off. Our video takes up a lot of the bandwidth. Perfect. And so I'll probably be able to hear you better now. So I know that you have filed your case. Have you given it to the sheriff or a process server? Okay, so you gave it to the sheriff to have her served. Is that right?
Yes, that's correct.
Okay. Have you received a document back from the sheriff's office that lets you know that that actually happened?
No, we just have the receipt.
No, I just have the receipt.
Okay. All right. Thank you for that information. I'm going to ask Ms. Knowles a couple questions. So Ms. Knowles, thank you for being here today. Have you received a copy of all the documents?
I have received a copy of one document.
Okay. What was the document you received?
It was saying that I have court today.
Okay.
Because he filed for a immediate restraining order ex parte when I tried to file one.
Okay. Okay. So
when I got here this morning, I got this. I paid to get this.
Okay. Just one moment. So here's the way this process works so that you both understand. What I have, well, number one, the way the process works is this isn't a time where people testify and swear in. Everything that I have to consider has to be in written documents that are filed with the court. Those have to be filed usually about a week in advance for them to make it into the computer system. So I don't usually look at actually paper files. I look at electronic files, and there's a little bit of a time lag from the time you drop it off to the time it gets scanned in and makes it into my system. If I was to make decisions today, obviously I don't have any information provided by you, Ms. Knowles, and then it would be, hold on, I'll explain, and then I'll give you another chance to talk. Then it would just be a one-sided case, right? Because then I'm basing everything that I'm deciding only on what has been filed. And so far, what's been filed is only by one party. And that certainly wouldn't be fair to only consider one side of the story. The court really wants to listen and understand both sides of the story before I make any orders for children. So what I have is the initial documents that have been filed, but I don't have anything from the other side, which is what I need to make a decision. Okay, Ms. Knowles, go ahead. What do you need to ask?
I would like to know when my daughter's returned, because I have a court order from 2014 from Oregon because Chris had stipulations for him to be in his daughter's life, did not do them, and he hasn't been present since 2014.
So this is where I said that this isn't a time where we testify. So you're telling me really potentially critical information, but it has to be written and it has to be filed for me to be able to consider it. So you're sort of saying, well, I want to tell you information and ask the court to make a decision based on that. Hold on, when I'm talking, then you wait, and I promise I'll give you another opportunity to talk. So we have to base it on, I have to base my decisions on what's in the court file. And I can only see the things that have already been filed. So you may have important information. I don't know. I just can't see it right now. All right. So with that, does that make sense? Do you understand, ma'am?
Yeah, I understand, but how is it that I have to pay to get my own court paperwork and completely miss court? This is the second court date. I haven't received nothing besides trying to find my missing daughter, get her the help that she needs, because she has court orders, things that she's supposed to be doing, and they're withholding her.
Okay. So here's what we're going to do. Sounds like the sheriff's office has a full set of the paperwork. So you should be, if you're in the courthouse, you should be able to go downstairs and ask them about it. And they should have a full set to be able to provide to you at no cost to you.
Why is it, does I still have to be away longer from my daughter because nobody did their job and I'm not getting served no papers? I had to buy papers when I came in this morning.
I understand. I have to base my decision on what's in the court file. I cannot base my decision on things I have not seen or things that you're telling me today. So here's what I'm going to do. In this matter, I'm going to set the matter over 1 week.
School next week.
I understand. I cannot base my decision on things that are not filed and things that I cannot see. So I'm going to set the matter over 1 week. That gives Mr. an opportunity to file proof of service. And that allows you an opportunity to file a response, which is what you need to do so that the court can understand your position and what's happening.
She
All right.
walked out.
I understand. So, sir, you understand that you need to file your proof of service. Ma'am, you'll need to file your materials. And then the court will consider it. It's the same date. It's the same day and time as I'm having a hearing today. So it'll be 9 o'clock next week at this same place. And then we'll have a hearing. I encourage everyone to file anything that they're going to file right away so that it's in the court file to be considered.
On Thursday.
Okay. So
Okay.
that's my ruling for today. I see you raising your hand, ma'am. If you can speak calmly, I'm willing to listen to you. So you'll need to unmute and then you can speak.
How is it that my daughter has court ordered things she's supposed to be doing and they're withholding her?
Because right now there is a Washington order that dictates where she's going to reside. And I don't have any information that would allow me to make a different order at this time. So that's why. So I have to base the information on what's in the court file right now. So you'll both need to file anything you need over 1 week.
My daughter, because nobody did their job. And
Ma'am, you're done. I've made my decision. The current orders will stay. We're setting the matter over 1 week. I'll see you everyone back here in 1 week.
Thank you.
All right. And I'll sign the orders that you provided, but it's just going to reference that the next hearing is 1 week.
Okay, thank you. I appreciate it.
We are. All right. And I have, Ms. Corey, this matter on to review payment status.
I have had a really difficult time getting in touch with both parties. They apparently have come to an agreement and have not yet filed that with the court. And Mr. Miller has not yet paid me.
Okay. So one party is paid, but not the other. Is that fair?
Yes. Ms. Young gave me a retainer of $1,600. At this point, I am, if the invoice I have has about 10 and a half hours on it for $1,575. So if Mr. Miller were to pay me the $787.50, half of the $1,575, I could refund some of that to Ms. Young. But
here's what I'm going to do. At this point, I'm going to go ahead and release you from service on this case. If the parties don't want, the parties are not motivated to continue with your services. I don't want you to have to keep showing up to hearings like this and sort of spinning your wheels. So I authorize you to go ahead and just not issue a final report, but just issue essentially a non-compliance that the parties aren't complying with you, that this is your final invoice. And that the court authorizes that you to pay yourself out of what's been paid so far. And if the parties have disputes about who should have paid what, they'll need to bring that back to the court.
okay,
That sort of puts the ball back in their court.
okay. So is that a actual document I need to file?
My preference would be that you like treat it like a GAL report as far as like the caption and the like, but like essentially a cover sheet. And you can even just do it as a letter. That way, if it's a different judicial officer, they'll understand what happened. So
Okay.
just that the court's authorized you to withdraw. This is the invoice at this point, and that if there's any disputes, the parties we're getting payment, and then the parties will need to bring that back before the court.
Okay, thank you.
And
All right,
has
thank you for being here.
Hamir joined the case?
No, he's no longer my lawyer.
Okay, very good. So what my docket notes is that this was put on for entry of agreed orders, but then I see lots of materials that were filed. So I'll turn to you first, sir. What do you believe this is on for?
Sorry, Your Honor, I didn't hear you correctly.
Oh, okay. What do you believe is before the court today? So that just means, what do you think that the court is deciding today?
Today was supposed to be decided about Kaylee Lovato staying with me for the summer. And I was trying to argue over the last court case, but it got pushed over about Bailey staying with me as well due to some of the things that were going on and her wish to remain with me.
Okay.
And there was a bunch of incidents that have been going on at the house and other things that just got brought to my attention. And I was just trying to get that all taken care of and make sure I get the paperwork for Kaylee and possibly Bailey to start school.
Sorry, I'm just looking at your file. Court granted adequate cause back at the beginning of the month. And, okay, so here is my problem. You folks, you probably have heard me mention to some other folks. Some things were filed very last minute, and so they're not in my system. I do have bench copies, but they were just handed to me this morning. Where's the child currently residing?
So I have them during the summer during the school year, and he actually has them right now during the summer. I actually am set to fly out there tomorrow to come pick them up so they can start school, because Bailey starts cheerleading next Monday, and they all start school on the 28th.
Okay. And then, sir, for your school district, when does school start in your district?
They started last Thursday or last Friday, and that's why, but I can't enroll them without orders saying that they're here with me. And that was the issue.
Okay. Got it. All right. So here's what I want to do. At this point, they're kind of missing school no matter what. Because the materials aren't in the court file, I didn't prep this case, and it was listed on my docket as an agreed order, which is very different than what seems to be the actual case here. So I'm going to set this matter over 1 week. I want the children to remain where they currently are. So I understand that may cause some flights that need to be changed and those types of things. I want them to remain, but just for this week. And then that way that the court can review the materials. This is a significant decision. I don't want the court making a decision without being fully prepared to do so. And so that's why I want to take the fair amount of time to consider what the best thing is for these kids. So with that, anything that anybody wants to file, please make sure you get it in essentially no later than tomorrow. And then I'm going to set the matter over 1 week to the 24th. So that's just next week, the same time, the same place. But that way that the court can consider and have adequate time to review all the materials.
So, Your Honor, actually, Bailey, they haven't started school here, and I've had the judge not last week, but the week before, had granted me adequate cause for me to have the kids because he had willingly moved to Alabama. So for me, and these girls have called me multiple times wanting to come home because we were all agreeing on Kaylee staying there just for a couple months just to see how things are going with her. And she's been calling me, crying, saying she doesn't even want to stay there. And
I understand. But again, what the court signed was an order of adequate cause. The only thing that order means is for a judge means I'm going to look at it. I'm willing to look at it because we don't willy-nilly change final parenting plans for kids. We want kids to have stability and assurance that they're going to have a stable placement and that the court's not going to rip them back and forth all the time. So adequate cause is a threshold decision, meaning that before you can even ask the court to make changes, you have to sort of make it through this doorway. And so that's the only thing that the court signed the last time on August 3rd was the court opened the door to consider what would be decided, but the court didn't say what was being decided. And so that's why it's important that the court takes sufficient time before making a decision.
Okay, also, like Bailey, she starts cheerleading. She has tryouts next Monday. And if she doesn't make that, and this is what she's been looking forward to the most, is cheerleading. And I've been trying to jump through hoops, trying to get her to even be able to do this. And I got the email saying that she starts on next Monday. And if she doesn't make that, then I don't even know what would happen. And I'm supposed to set out to fly there, which Brandon is the one who actually paid for my plane ticket to go out there to pick the kids up. And I fly tomorrow.
Yeah, I understand. The court is not the one that put you folks in this position. You guys put yourself in this position. When I look at the court minutes are from August 10th that the two of you are working together, continue a week and submit an agreed parenting plan. That is not what you're doing. You're asking the court to do something completely different than previously. So,
right, because this was just kind of like thrown on me last minute.
I understand. So there's sort of consequences for that. And the court, again, the court thinks that where your children live is more important than cheerleading. And I understand those things are very important. And I give every credit to kids but I want to make the best decision I can, or whatever judicial officers here wants to make a very good decision. And I can't do that without enough time to read through the whole file and understand and make a good decision for these kids.
Yeah.
So
Okay.
that's the court's order. I'll set it over 1 week. Again, if there's anything additional that either of you want to file, sort of now is the time. I'd ask that it be filed no later than tomorrow, so that there's enough time for it to make it into the court file before the next judicial officer preps the case.
Okay, and also I have like videos and stuff of like him. I have police reports of him trying to run me off the street with our kids in the vehicle. I have text messages proving everything to be true in my statements.
I can't tell you how to run your case. I have to be neutral. So I can only tell you that anything you want to file, you need to file. And if there's other things that you want to get before the court, I'm going to leave it up to you to seek counsel or advice on how to do that.
Okay, so for like videos and stuff, can I present those, or how does that work with videos?
So that would be me giving you advice, and I can't do that as a neutral decision maker. So I invite you to reach out to either you can find a lawyer for a consult, or you can reach out to Legal Aid and other organizations, court website, all those things to give you options.
Okay, all right. Well, thank you, Your Honor.
All right, thank you both. We will see you
Ms.
here
Corey,
next
are you
week.
on that matter?
Okay, thank you.
I am.
All right, very good. Okay. So let's see, I have a contempt filed by Mr. Sorensen. So I'm going to address I'm going to have you go ahead and make argument regarding the contempt, sir. And then we'll talk about the adequate cause next. So go ahead. I have had an opportunity to read all the documents in this case. I appreciate that you both filed documents and materials. Sir, why don't you tell me what you want me to know about the contempt?
The parenting plan, Section 8, Part B, has been broken since she's withholding our child, rejecting visitation after Christopher fled from my house to Miss Fike's sisters during our parenting time. She is in violation of the week on, week off schedule. She refused to bring him home to me or comply with police officers to bring him to me, or to cooperate as a parent in any way to communicate, discuss our current situation, as you can see from the text that I had filed. Section 14 under restrictions was also violated, where she discussed the residential schedule with our son outside of already agreed upon parenting plan. She discouraged our son to not attend and led him to believe it should be his choice. He came under the impression his mother hates the ruling set forth by Judge Evans, and that she is not the one making him come to my house, that it was a stranger making these choices for him. It is my understanding that Section 14 exists because Christopher benefits if he is under the impression that both parents are on the same page with respect to the current plan. He should be under the impression that the courts are looking out for what is best for him. It would benefit transition day to see both parents be supportive of one another in front of him. The opposite happened. By not setting a positive example of the transition, I believe it set the stage for our son to flee. Our child was not in any way in danger, harmed, neglected, or suffering. After our son sneaking out, she had no legal right to keep him away from me. Christopher's transition to my house was well planned, including therapy sessions, church, a basketball camp, and reunification counseling. He had everything in place for a smooth transition, but it was stolen from him.
So when is the last time you had your son in your care?
The 22nd
of June?
August.
Okay. Wait, hold on. So it's August now. So
yeah, June. Sorry, I'm sorry.
Okay. So June 22nd, and you haven't had your son in your care since then?
No.
Okay. Have you had phone contact with him since then?
I've tried to reach out to him via text, and I haven't received anything from him back.
Okay. Thank you. So I'm going to handle these one at a time. I might make my decision all at the end, but I want to kind of do one operation at a time. Ms. Corey, tell me about your involvement in this case. So I see old orders in this case, or old GAL reports, but I don't see a current, and I don't see an order appointing you. So tell me how you entered the case.
So I was appointed, I believe about 3 weeks ago. I believe it was by Judge Evans, and it's been kind of a comedy of errors. I have not yet gotten an order appointing.
Okay.
But because there was a very quick turnaround, and Judge Evans was looking for an initial review next week in this case, I went ahead and got started and sent intakes out to the parties. They filled them out. I've interviewed both of the parties so far, but because I don't have that order appointing yet, I'm just kind of stuck at this point.
Okay. Very good. That makes perfect sense to me. So I appreciate that. Have you been able to talk with the child of the case?
Not yet. Because it's outside of the school year, and I like to speak with the children in a more neutral place than one of the homes. I have been. I believe I have a place to do that secured, so I'll be setting that up soon.
Okay, very good. I appreciate that. All right, Ms. Hall, what would you like to say about the contempt?
I am Miss Fike. I've been married over a year now. Sorry about the paperwork, but my last name is Fike.
Okay, so when you name yourself on the screen, go ahead and name yourself Ms. Fike instead of Ms. Hall, and that's certainly helpful to the court, giving you the correct name.
Okay, I didn't see my name on here at all. Okay, so on June 25th, my son refused to go to his father's house due to mental and emotional issues that we've been going on for years, as of the other court papers. We had a court date July 20th. That was when Miss Corey was appointed to us to figure out why he refused to go to his house and figure out what the issues really are. Judge Evans said he appointed Twyla for Christopher's voice. He ordered Christopher to go to his dad's July 21st, that next day on Friday. So he's seen his son at the end of July, not June. Christopher went to his dad's. Well, his dad showed up. Christopher took off down the street. His dad went after him. They ended up leaving together after they talked. Just for me to get a call the next morning that he ran away from his dad's house. Talking to the cops, they never told me to bring him back. They said they understood and to keep him safe. So I don't know what he's meaning, what the cops said to him, but what the conversations with the cops with me were totally different. And they were aware of the court. They were aware of the guardian ad litem. So for me to try to keep my son safe and why he's refusing and running away from his father's house, I want those things to be addressed. I'm not withholding Christopher. I'm not keeping him from his dad. If he goes there again, what if he runs away again? So I'm trying to think of down the line. No, I'm not withholding him at all. Christopher refused. Christopher ran away from his father's house. And I feel like knowing all the stuff that's been going on for years, and I can't force him to go, especially he's 6'2". I'm not going to physically force my child to go. Yes, we need to figure out why he's not wanting to go and people to listen, but I am definitely not withholding my son from his father. That's the whole reason why Miss Corey is here, I can't wait for her to talk to him.
So does your son have a cell phone?
He does.
And he has it currently?
Yes.
Okay. Has he been in the last month visiting with friends?
Yes.
Going places?
Mostly my sisters, because I work, and him and his cousin Ashton are best friends. This whole summer, he's been to 4 different friends' houses on my time. 4 times this whole entire summer. So yes, he has.
What school district are you in?
He was starting his freshman year this year.
All right. Thank you.
He had his first counseling appointment with Core Health on August 1st. He had his second one on the 15th, just 2 days ago, with Core Health as well. So he is in counseling.
Did you provide the father with the information regarding the dates and times of the appointments?
No, but they were verbally said in court what times they were.
Did you provide the father with the name of the counselor?
No, because I just found out the name of the counselor just last week, because we did the intake with a lady named Linda, and I just met Hannah, which her name is Hannah from Core Health. I don't know her last name. On the 15th is when we met her.
Does your child have a diagnosis?
Not yet, no. They're setting up another counseling for this afternoon and hopefully next week.
Okay. How many times have you taken the child in the car and taken him to his father's house since that last July visit?
He hasn't been to his father's house.
Right. I'm asking if you put the child in the car and drove him over to dad's house.
No, I have not.
Have you dialed up dad on the phone, handed the phone to child and said, you need to talk to dad?
No.
Okay. All right. We're also before the court on the issue of adequate cause. So ma'am, you filed those documents asking for adequate cause to modify the parenting plan. What would you like me to know about that?
The reason why I want to modify is because of his refusal and not wanting to go. I want him to see his father. I want him to be able to have that relationship with him, but there's also something going on there that we need to figure out.
Okay. Sir, what would you like me to know about adequate cause?
Well, I mean, this has already been proven that there was no adequate cause by Mr. Evans. I don't really, as of right now, I mean, other than since he's been in Miss Fike's care for the last few months, I've been receiving countless. He's been sneaking out, running. He ran away from my house. He's cut himself off of all of his encouraging friends and relatives. That's where I'm at.
I see
Judge
that
Evans
you-
appointed Twyla to figure out what's going on. So with that being said, I feel like Judge Evans, excuse me, in a way, not believed, but believed there's something going on, that he said guardian item to be Christopher's voice. So I don't understand. We get two different aspects of what.
When was that hearing held?
July 20th was our last court date, with him refusing to go to his dad's.
I'm just looking for the clerk's minutes. Okay, here we go. So did the court just put it on today for review? Because it sounds like the court previously found contempt. So the court found contempt on July 20th. The court found contempt, denied adequate cause, will sign the order, and court appoints guardian ad litem. Initial review next week. So this is your second contempt, sir?
Yes, ma'am.
Okay, so I was just clarifying because it looked like when I initially prepped for today, it looked like because there wasn't, I didn't have that note as far as the adequate cause being decided. I did see the second contempt. Okay, so then we're just on for those two things. And then Ms. Corey, what I'm going to do today before I leave is to issue an order for you so that you will have that today. And I will ask my clerk to send that or my JA to send that out so that you get a copy of it and can start executing on it. Did the court set financial obligations or no? To your knowledge?
I do not recall. I believe it was private pay.
Okay, that's fine. I'm going to do private pay and I'm just going to make the parties 50-50 at this point for your services. We'll keep it on next week for that review. And then give me just one moment. So that's. And so, sir, I just want to clarify, when is the last time that you saw your son? Was so July?
Yes, ma'am. When he was ordered to come to my house for the Friday, which he didn't want to give me any lost time or anything, but we were supposed to resume the regular parenting plan of week on, week off. And then he fled my house that next morning, and then I haven't seen him since.
Just one moment.
Other than that short little window that I did receive him, it's been nearly 60 days since I've had my son, which is, I mean, I've never been more than a week.
Yep, give me just one minute. And ma'am, it's your testimony that I saw there was a statement from the child, and it's your testimony that that was the child's statement that you asked him to write.
Absolutely not. No. On June 25th, Christopher was supposed to go to his dad's at 8 p.m. that night, and he calls me in there a little before 6. Says, "Mom, what would happen if I refuse to go to my dad's? I don't want to go. I'm tired of everything." So we talked to him about it and what would happen, and he said, "I'm also writing a letter." He was in the middle of typing that said letter, and he said he wants me to read it when he's done writing it. So no, I did not make him write. I didn't tell him to write. It was a surprise that he was, not necessarily a surprise because he's never wanted to go to his dad's, but he's always went. He's never refused. He's never ran away. I feel like there's something going on because nobody's listening. There's something going on over there, why he refused and why he's moving away.
Thank you. You've answered my question. I appreciate everyone being here today. I appreciate Ms. Corey being here today. I am going to find contempt. I'm going to enter a civil sanction of $1,000. I'm finding that the mother is able to follow the court orders, but is not willing, that you are intentionally defying the court's orders. I'm also making a separate finding that the mother is directly involving the child in the court process, and that you are encouraging the child to disobey and making no effort to follow the court's orders. Here's the reality. Nope. This is where I talk. I've given everyone a chance to talk and I've listened. When I read the court file, here's my take. If I was making a decision on adequate cause today, I'd make that finding and I would transfer full custody to father. That's your risk, ma'am. What you're doing right now, you are fully aware of what you're doing. You are deciding that you are going to disobey the court order. You're not encouraging your kid to go. You're allowing your child to believe he has some kind of say. He does not. This is a parental decision. And if the two of you can't make that decision, it's the court's decision on where your kid's going to live. Your child is more important than ownership. And what I see in this case file is ownership, is somebody wanting to possess that child, own that child, but not parent that child. And that is a huge concern for the court. When I see these nice text messages between child and stepmom, and then you telling kid, you don't even have to answer her. You don't have to go to that sports game. That's ridiculous. When you tell a child, especially a young teenager, you don't have to respect that adult. You know what that translates to? I don't have to respect mom. I don't have to respect dad. I don't have to respect my teachers. I don't have to respect the court. I can blow all of that on all those people off. So when you think that you're just telling, oh, you can disrespect kind of stepmom, that's not what's happening. You're telling that child he can disrespect everyone. That is terrible for that child. You have 4 years left with this young man before he is launching off to adulthood, and you are setting him on a course for disaster because you are setting him up to think that he can just disobey everyone. And that is not how school works. It's not how the world works. And that's going to be a harsh reality for him. When you do those types of things, it is so damaging. And especially when what I see on the other side is folks being loving and caring. Look, teenagers are hard. They are hard work. They are not easy. Sometimes they are just going to be disobedient and annoying and frustrating. But that's where you as parents come in, and you need to step up and say, you have to go to your dad's. It's your dad's time. You're going. And what you're doing right now is he's on his phone. He's playing his little games. He's going to his friends' houses. That all sounds like he gets to do what he wants. And you're teaching him that instead of follow the court order. It's at the end of the day, it's you that are going to pay the penalty for this, not the child. It's you that risks losing all custody of your child. I honestly had notes on whether or not there needed to be a pause in any contact with you, ma'am, before, and the child needed to be with dad and no contact with you for a period of time. That's how serious I take these orders. That's how serious the court takes orders as far as parenting time. So this idea that kid gets to be on his phone, dinking around, watching TV, eating snacks, all while you are fully aware he's disobeying the court order and you're disobeying the court order, that is not acceptable. And you need to think long and hard about your course of action, because you're going down a course of action that I don't think you're going to like the outcome. So at this point, I'm signing the contempt. Ma'am, I highly recommend that you ensure child goes on his visit with his dad. And it's not a visit. Child needs to go to dad for his dad's residential time. Dad is an equal parent here. And everyone needs to realize that and get on board really quickly. Because at this point, the court hasn't found adequate cause, but I think the court essentially is reserving that issue, and it can go the other way. The court can find adequate cause and award father full custody. So that is the risk here. So I encourage everyone here to really quickly get on board with getting child to both houses as ordered. There should be no further deviations. Child starts school in a week and a half. The idea that we're going to play this game as child starting his high school career is ridiculous. Everyone needs to get on board with what the child needs and stop sort of playing these games. Encourage relationships with both sides. Stop alienating father and father's family. That is not helpful to that child. You should be thankful and grateful for every adult that wants to be, every positive adult that wants to be involved in your child's life, instead of trying to encourage your kid to blow them off and ruin that relationship. That's not healthy. It's damaging. So I'm making a finding of contempt. I'm sending the matter over for 1 week. Everyone needs to communicate with Ms. Corey anytime that any documents she asks for, any materials she asks for, any access she asks for to anyone. Everyone needs to be Johnny on the spot with that. And then Ms. Corey, I don't think the court's expecting a written report from you. I think an oral report will be just fine, given the sort of limited nature of your ability to chat with everybody and the court not getting that order entered.
Thank you.
All right. So I've made myself very clear. It is my expectation that that young man will be exercising his regular time per the court order. Best of luck to you all. We'll see you here next week. I have on for review. I see service as to both mother and father. There was an emergency order quite some time ago. Where are we at on this matter?
This is the review hearing, Your Honor. The order is due to expire on the 25th of this month, temporary guardianship.
That is correct.
My name is Linda Astolet, by the way.
Okay.
I'm temporary guardian.
Okay. And so at this point, you are correct. The order is set to expire. Absent anything more being filed, the order will just naturally expire, and then child can be returned to a parent or.
Right. As to my knowledge, no more further paperwork has been filed. So, but my daughter is living with us, so the children are here with her as well. So,
okay, very good. And so children and mother, and that's Lindsay.
Yes.
Okay. Okay. So then with that order will just expire of its own accord, and I'm not going to set any further reviews. If you need further action from the court, you'll need to start a new action.
Okay. Okay. Great.
Okay.
Thank you.
Thank you. That's it for this matter. Also on
you.
for a review. So in this, who do I have present on? I see you there, Mr. Jason Chappell. Do I have anyone else present on that?
I'm here.
Okay, I see you there.
I'm here, Your Honor. I represent Shauna Ray, the mother.
Okay. Okay. And so I see you there. Appearing by phone. What I'll need you to do, is it Overby or Overby, if you would turn your video off and leave your audio on, the video takes up a large piece of the bandwidth, and so it sometimes will make the audio so choppy that I can't hear it.
Your Honor, and also Mallory Smith, Guardian Ad Litem, is present as well.
Thank you. All right. So we were last here last month. The court had allowed, at least from my review of the file, court had started allowing some lay supervised visits and potentially some Zoom visits. There was notes on sort of an expectation that visit notes would have been filed or problems with visits, if any, would have been filed in the court file. And I didn't see anything had been filed. So I'm going to turn first to Mr. Anagnostou.
Thank you, Your Honor. I got good news to report to the court today. The issue up until just a few weeks ago was my client's housing. She did not have appropriate housing. She was residing with a roommate that had some not nice dogs, and the children couldn't go to where she was residing. She's resolved that. She's now in the community house, and because she's in the community house, there's no issue with regards to drugs. It's a drug-free facility. They have appropriate places for her to feed the children, and ultimately the children could live with her in the community house, and that's what she's going to be pursuing. This all happened within the last couple of weeks. It's been maybe a week or so that she's been at the community house. I didn't get a chance to file a motion or declaration regarding these issues, but my client needs to have the children at the community house come visit her. We think that that's an appropriate facility. The children will be safe there, and she has continued to in her mental health treatment. She's compliant with all requests for UAs and those type of things. She's done them at the community house. There's no concern with regards to that. So we need to move this along, and she has been being stonewalled by Miss Overby, who has placement of the children at this point, on getting visits set up and having the phone contact. It's all everything gets canceled and dropped, and it doesn't occur. In the past, there were issues with being able to contact my client because of her phone issues. She's resolved that as well within the last week or so with she got a new phone, a new service. But Miss Overby is stonewalling her, and we need visits to occur. In particular, there's a birthday party this weekend on Saturday for a 1-year-old grandchild of my client, her older daughter, Paisley, and Rayden's older sister. And she, has been arranging this for a long time that the children would attend that. That's 3:30 on Saturday in Vancouver, and Miss Overby has said no. So those are kind of the issues for today, and then I can get a motion put together. The other thing we're concerned about is Miss Smith, is my understanding, is stepping down from the guardianship role, or from the court investigator role. She's the court-appointed guardian ad litem. And so I'm not sure what we're going to do about that going forward. My client ultimately wants placement of the children, and she's working on her issues. There we are. That's what we have going.
Okay. Has your client had any visits since the last court review?
I don't believe so, Shauna.
No.
Okay. All right. Very good.
I've had-
I have Mr. Chappell on the line. Is there anything that you would like to say, sir? So you'll have to unmute. You can do that usually by tapping the screen, and they almost. There you go.
There?
Yes, go ahead, sir.
All right. I would like to have a physical with my kids visits.
Okay.
I was having only Zoom.
Okay. Have you been doing Zoom visits?
Yes.
Okay. How often are you doing those?
Weekly.
Okay. All right. Anything else you'd like the court to know?
I don't know how well Shauna was abiding or doing her visits. Her lawyers made it sound like Joe wasn't, fulfilling her end, which what I understand, Shauna wasn't abiding, fulfilling her side. So that's all I have to say.
Okay. Thank you, sir. Ms. Smith.
Good morning, Your Honor. So as it relates to the visitation, it is accurate that Ms. Ray has not had visits with them. I've had initially, I guess at the last review, I should say, we had identified a layperson to provide supervision. And then shortly after that court hearing, she realized that based on the necessities of her employment, she wouldn't have as much flexibility to support that role. And so then she stepped aside from that. So ultimately, Ms. Ray had, she still had 2 visits paid for at Reconnecting Families, of which she attempted to schedule one. When Reconnecting Families went to confirm the visitation, it was kind of last minute, and they reached out to Ms. Ray several times, and even indicated wanting to support efforts and provide transportation to Ms. Ray. Ultimately, despite the fact that Ms. Ray initiated that scheduling, she became non-communicative, and that I would hope that the court could see that Ms. Overby has been very proactive in supporting the relationship that the children have with both parents. She's made every effort to remain consistent with the video calls, or the availability for video calls, the regular phone calls, and the visitations that have occurred at Reconnecting Families to the very best of her abilities. If there are conflict within the schedule, she's very proactive in trying to reschedule or make that known as soon as she becomes aware of those things. The visits have gone poorly. Quite frankly, I think that both children, based on my communication with providers from the WISE program, are saying that both children are really struggling with the lack of consistency as far as mother's ability to schedule and appear and arrive on time and engage in these visits in a healthy and meaningful manner. And it's been a challenge for them to kind of reconcile that awareness for them. I don't believe that visitations should be lifted as far as having the supervision. I think that restriction remains appropriate. As it relates to the upcoming birthday, I don't believe that Ms. Overby, from the communications that I've reviewed, I don't believe Ms. Overby is denying that the visitation or the children could or would appear. The challenge is that Ms. Overby has requested that she be able to be there at the party as well, since there's no other individual that has been identified to provide supervision for the children during this time. So that is the challenge given the upcoming birthday. As it relates to visitation, in-person visitation for our father, I think restrictions also remain appropriate as far as having supervision. I believe that father and Ms. Overby have an amicable enough relationship that potentially Ms. Overby would be able to serve in that capacity, but I would defer to the court in that regard. Lastly, as it relates to ongoing review of this matter, Mr. Anagnostiu is correct. I have recently taken a position with the Attorney General's office, and I'll be starting that in September. So I am respectfully requesting that I be discharged at this time, as I will not be able to provide investigative support moving forward.
Okay. And then Ms. Overby. Go ahead. What would you like me to know?
The calls with the children. I would like you to know that the calls with the children between Miss Ray and them go poorly every single time. This Tuesday, she ended up hanging up and yelling at them, and both children now crying because I'm sitting outside to not be intrusive. And with reconnecting families, we have made it every single day but one. A couple of those Shauna did not go, no showed. Some of those went very poorly with the children, very upset. I have not able to obtain the that I have requested from families. I feel like their input is necessary before unsupervised visits take place.
Okay. Thank you. So
Ms.
Overby, your audio is very, very choppy, to where it's pretty challenging. I think I understand some of what you're saying, but it's pretty choppy where I don't feel like I'm definitely not understanding 100%, because I can't hear all of your words. Okay. Here's what I'm going to do. In this matter, nobody filed anything between July and now. I think parties are kind of asking me to make some pretty substantial changes with really not a lot of evidence, if any evidence, before me. And I'm not comfortable doing that when I don't have anything significant before me. So here's what I'm going to do. I'm going to leave the current orders in place, current visitations in place. I am going to allow, I'm going to discharge Ms. Smith and appoint a new guardian ad litem. So what I'm going to do is, Mr. Anagnostiu, do you have any preferences as far as, is there any guardian ad litems that you would strike from the guardian ad litem list?
I would strike Ms. Farr.
Okay. And Ms. Overby, anyone that you would strike?
Excuse me, Your Honor, this is Sherry Farr. In the guardianship, on the guardianship registry, we don't strike.
Oh, all right.
It's just the next one in rotation. I don't have an issue not being appointed on this case. That's fine. But that procedurally, there's no provision to strike in guardianships.
Fair enough. I was using my regular procedure.
Thank you.
Okay. Thank you for bringing that to my attention. Okay. So my intention is just to take the next person on the list. And what I'm going to do is I'll draft that order and send it out. That same order will allow Ms. Smith to withdraw, because we do need input from a guardian ad litem and an investigation to be able to potentially know which direction we're going on this case. I'm going to set the next review out a couple of weeks. The idea is I want to get the guardian ad litem on board. Anybody's free to file motions in the meantime, but this is just the next court's sort of review. I'm going to set the next review for September 14th. So otherwise, all visits are to remain the same. Current guardianship will remain the same. We'll review. I am going to appoint an order. I am going to appoint a new GAL and enter that order today. I'll just do that once docket concludes.
Can I ask a question?
when I stop talking, then you can ask your question. And Mr. Ignacio and Ms. Smith, I'll try to have that order sent out to you so you both have copies for your reference as well. All right, Ms. Raitt, you're represented by counsel. It's your counsel's job to answer your questions. So I ask you to reach out to him.
I guess I do have a question about the birthday party this weekend.
I'm not making that order. I appreciate that parties want to do those types of things. Those also can be events that have a lot of emotions behind them. And it doesn't sound, at least so far, like, again, I don't have any information before me that anyone has filed that would have me change the current orders. Previously, we were doing professionally supervised visits. I don't have anything before me to make those changes. So I'm not going to. So again, anybody's free to file any motions that they desire, but I'm going to set that next review out to the 14th.
Okay.
All right. That's it for this matter. Just a moment to get that case file up. All right, I have Mr. Anagnostou representing Daniel Howlett. I have Mr. Gojak representing Tracy Miller. I have, let's see, do I have Mr. Deerheim present? Don't see him. Or Taylor White?
Yeah, I'm here. He's
okay.
Brad's at work.
Okay, very good. Thank you. I did receive from Mr. Anagnostou's office several personal healthcare records. So I did receive those, had a chance to review those.
Apologize, Your Honor. I don't believe I've received copies of those. Mr. Anagnostou, did you provide that to me?
I did not. I apologize. I didn't see that you had been appointed to the mother.
No problem. You can just email that to me, or I can put my email in the chat.
Yeah. For the record, I have filed a petition to terminate the guardianship and return the children to my client. I will get that to you. My client has been in conversations with the guardians, and they're in favor of terminating the guardianship and returning the children to my client.
And I have, sorry, Your Honor, I have.
You don't have any notice of that. I apologize.
No. I was also going to say, I also have not been able to get in touch with my client, so I don't have a position on that at this time. I will continue to try to get a hold of her, but I just don't see any other way unless both party knows another phone number or email or Facebook for her. I'm just out of options.
Thank you, Mr. Gojak. Ms. White, Mr. Anagnostou is indicating that you are in favor of terminating the guardianship.
Yeah, Brad said that was fine.
Okay. All right. So that being heard, and when I reviewed this file, I have a pretty old petition that was filed. And it looks like it's kind of limped along on temporary orders, but I don't see another petition besides the emergency petition that's been filed in this case. And those are only designed to last so long under the statute. They aren't designed to sort of go on in perpetuity. That being the case, is there anyone else who wishes to be heard on this matter? Yes, sir.
I want to let you know that, I graduated from inpatient treatment. I'm continuing outpatient. I'm doing everything I can.
That's Mr. Howlett, the father, by the way.
Okay, that's your client, Mr. Anagnostou.
Yes, that's my client.
Okay, thank you, sir. I appreciate you being here. You're represented by Mr. Anagnostou, so essentially he speaks for you. Based on my reading of the statute, this order should terminate anyway, just based on it was extended longer than it should have been, because it's just an emergency order, not a final or permanent order. So that being the case, I'm not renewing it. Mr. Anagnostou, I'll just invite you to submit an order. Oh, and it looks like maybe you did.
I did, but I didn't realize Mr. Gojak was appointed, and I assume I should have got him these documents.
Yeah, what I'm going to do is I do see that you submitted this to me. I'm going to have you go ahead and circulate it because it sounds like the parties are in agreement. Well, actually, before I do that, Mr. Gojak, this is what I have before me is an order and findings on petition to terminate the guardianship. I'm going to leave it up to you. I can either essentially just indicate that this order does terminate the guardianship. No fees and costs to anyone except fees for the court to pay Mr. Anagnostou. Are you in agreement with that order being signed?
As long as that order also says that I'm getting paid, I'm okay with it.
I will indicate you will submit a motion in order for prompt payment. How about that?
Will do, Your Honor. Thank you.
Kayla, thank you.
There we go.
Jennifer Goodell, appearing on behalf of the petitioners, Your Honor.
All right.
Your Honor, I
Craig,
represent Kayla, the youth.
and I represent Danielle Jones.
And Your Honor, Attorney Dino Goyak here representing Anthony Randall Sr.
All right. Very good. Give me just one moment, get that file opened up. Let's see. Okay, I got Mr. Gojek that was appointed and him on board. Looks like I have proper service of everyone in this case finally happened, or at least was filed. Ms. Bliss got appointed. All right, I'll turn the time to Petitioner's Counsel first.
Your Honor, I don't know if we're going to be proceeding this morning. Ms. Bliss was just appointed a couple days ago, if not yesterday, I believe. And I haven't seen anything in writing from Mr. Anagnosio on behalf of his client, which this was continued over to have that be done. So I'm not sure. I guess I would like to ask the other counsels on the line if they're planning to proceed today or if they're going to be asking for a continuance.
Fair enough. I'll turn to Ms. Bliss first. So you were very recently appointed. Are you ready to proceed today, or do you need additional time to meet with your client?
I have had the opportunity to speak with my client, so I am prepared to move forward today. If we do, I will note that I did receive some materials from Mr. Anagnostio's office just before the 5 o'clock hour yesterday. So I haven't had the opportunity to review those nor go over those with my client. So I guess I would defer to everyone else as to if they're ready. But I do know that Mr. Goyak was also just appointed, I believe, yesterday or the day before. So he might have some issues as well.
Okay, so then I'll turn to you as Ms. Bliss has kindly handed it to you, sir. Mr. Goyak, have you had an opportunity to meet with your client, or do you need additional time?
I've not had an opportunity. I actually don't even have any contact information for my client. So if any of the other parties do have information for the father, if you could please share it either through email or give me a call, be appreciated. And Mr. Anagnostio, if you want to send me that paperwork also on this case, the father, I'd appreciate it. I guess I would be requesting at least a week set over so I have a chance to talk to my client.
Okay. And did you get the materials filed by Mr. Anagnostio? It looks like they were filed yesterday.
I have not.
Okay.
I also have not seen those.
Okay. All right. Mr. Anagnostio, I have more than one request for continuance before me. I'll give you an opportunity to speak to that.
I guess on behalf of my client, if the court's going to continue this, and it sounds like they haven't gotten my client's declarations, and it hasn't been. We got that out late yesterday. We were working with our client to get a signature. She lives in Portland, so it was by email, which is always problematic. But anyway, if we set it over, we'd like to set it over just 1 week to next week because my client wants to have some contact with her daughter. Her daughter is 16, and I know her and Ms. Bliss will weigh in on that issue, but she really wants to have at least some telephone contact or start some kind of reunification counseling. It's in her declaration. But if we set it over, if you just set it over for 1 week so we could get that process moving.
Okay.
I did see that we were.
Go ahead.
My apologies. I did see that we were already scheduled to be on for the 23rd for the full petition. So I don't know if it makes sense to maybe put them both on the same docket.
That works for me.
If they can do that.
Yes, and that's even a day shorter, Mr. Anagnostio, so I can shave it down a day. So that's what I'm going to do is I'm going to put this over to the 23rd. Sounds like we're having the hearing regarding the full petition on that day. Anything that anyone wants the court to review needs to be filed essentially by tomorrow. Anything that you have filed within the last week, you now are aware of all the counsels that are involved. If you have filed it within this last week, please send another courtesy copy via email to the counsel, all the attorneys involved. So everybody is on the same page. Everybody has the same materials. And then that helps reduce risk of an additional continuance because someone doesn't have one of the materials that are provided.
I'm sorry, Your Honor. I think that was.
So I'm going to set both matters to the 24th. I think what someone did was they put you on the adult guardianship docket, and that would not have worked out. So I'm going to put both matters on for the 24th, this same place, this same time. And then that way we can address that. I'm going to have, Ms. Gunnell, I'm going to have you submit an order to extend the emergency guardianship through next week. And you can just, if you can circulate that amongst the parties and then send it in next party, we can get that signed.